Now, from the American Enterprise Institute in Washington, D.C., author Richard Epstein discusses his forthcoming book, Skepticism and Freedom, a defense of classical liberalism. In it, the author argues that America's current legal system is based on property rights, freedom of contract, and limited government. This event runs an hour, 5 minutes.
Richard Epstein is one of the great legal scholars of the age and one of the great expositors of the principles and institutions of individual liberty. In addition to a copious literature in the law journals and magazines and journals of general circulation, and a long tour going back to the early 1980s as editor of two of the great academic journals of the time, first the Journal of Legal Studies and then the Journal of Law and Economics, both at his home, the University of Chicago Law School. He is the author of a string of highly important books on healthcare, affirmative action, other issues, including most notably his recent Principles for a Free Society, Reconciling Individual Liberty with the Common Good, and his well-known book, Simple Rules for a Complex World. When I heard that Professor Epstein was writing a book with the title Skepticism and Freedom, and being highly impressed with the ambition and scope of what I assumed the book would be, I asked him how long he had been working on this book, and he replied, 30 years. I think that you can guess from the title of this book, which will be published by the University of Chicago Press this coming fall, that it is in many ways a fulfillment and an extension of much that has come before in this man's distinguished intellectual career. His lecture this evening is by that title. It will be a sneak preview of his upcoming book, and I ask you all to join me in giving Richard Epstein a warm welcome.
It is very nice to see so many nice friends here, and many of whom go back for the 30 years about which I've been thinking about this and other kinds of books. If this were a crowd which wasn't so friendly, I would actually take the book out and try to read it to you in the 35 or 40 minutes that were available to me. But I somehow had the thought that I should take an alternative course of action, which is to try to jump from peak to peak, running the serious risk in an exposition of this sort that I might fall into some rather deep valleys, which I will leave unexplored in a talk of this particular sort. My view is I'm supposed to go, 35, 40 minutes? I don't know the drill. And then take the questions, and of course in the questions I will manage to remedy all of the serious defects and omissions that I've made in the talk. Now, and I was trying to figure out how it is I was to try to position this talk. I said, I'm now at AEI, and so what I have to do is to assume an air of reasoned moderation in which I managed to imitate the good and strong intellectual and corporate culture which has dominated this place. And so what I'm going to do is to try to describe all the kinds of ways in which this book, in fact, makes me Aristotle's main man of the 21st century. And the first of the kinds of, shall we say, moderations that I wish to talk about in this book is to indicate to some degree the sorts of substantive positions that I'm trying to avoid, and then to try to tell you something about the methodological traps that I am trying to avoid. And of course, the appropriate strategy with respect to both of those things is to show that there's somebody to your left and somebody to your right, so that you, in fact, have the virtues of the golden mean. And when you're trying to figure out what the substantive positions are that you are having to deal with under these things, one of them is, in fact, a position to which I have a great deal of affection. It's what you might want to call a stripped-down version of the libertarian theory, very powerful visions of the minimum state, in which the essential proposition about government is that its sole force is to avoid harms to other individuals, where harms to other individuals are going to be described in the narrow terms of the prevention of force and fraud. And there's no question that there's a great deal to be said for the affirmative case there, that you have a government that does at least those sorts of things. But it seems to me on end that it will not be able to account for many of the common features of our ordinary organizations, and that we therefore have to bolster the theory. So, for example, it is generally accepted that we have a system of taxation, at least some system of taxation that's going to be appropriate. It's also clear that the government seems to have some role in respect to the sort of the supply of various kinds of social infrastructure, and neither of those two functions fit very easily within this particular framework. So the question now is, how do we make government a little bit bigger than us sort of small-time libertarians would like it to be? And it's painful to me to recognize that we have to go that far. And one of the reasons why it's so painful is that you might end up going a great deal further. Because one of the tendencies on the other side, which I'm equally anxious to avoid, is the position which says, since you cannot give yourself a narrow and limited definition of what government does, essentially what you have to do is, in constitutional and political terms, is to recognize that the state that you have can do more or less anything that it pleases, so long as it gives at least some nod to advancing the common welfare of the good of the population at large. But that any kind of intervention, regardless of its particular social program, is, if passed with that kind of benevolent motivation, going to be sufficient unto the day. And this, of course, travels under many versions. At one time, it used to be the sort of the socialist ideal that we could figure out how to have ideal distribution and ideal production just by ringing the various kinds of price indicators through central planning. I'm happy to say that a guy named Hayek got to that issue a little bit before me, and I was able to explain, I think in fairly powerful form, why it is that that form of centralized planning doesn't succeed in the terms that it advances the argument, namely that it isn't able to produce the kinds of productive outcomes that we'll have. Mr. Khrushchev did not bury us. It turned out that the Soviet Union disintegrated under its own weight by the late 1980s and the early 1990s. It turns out, however, advocates for larger government are a very hardy breed, and in many cases they will now take more modest positions. And the one in which I think there's been a great deal said in this country is, of course, for the sort of comprehensive welfare state, the kind of thing that we have today in the United States, which works with a greater success than socialism, but essentially takes the proposition that in dealing with general matters of economic regulation, there is no powerful side constraint of constitutional law or legal principle which prevents the legislature from doing exactly what it pleases and exactly when it pleases to do this, so that Rex Harrison's versions of what My Fair Lady ought to be about seems to be much of the modern political theory. Now, in dealing with this, I'm actually a moderate, because I do think, in effect, that one can escape the dangers of being the hardline libertarian without going into a position in which comprehensive government action is the order of the day. And so the subtitle of this book, which I added when I realized that no one would figure out what the title meant, was, in effect, a rather simple observation that it was a defense of the classical liberal position in which there are relatively limited kinds of government functions that are legitimate and large numbers of other things that fall outside the sway of proper government action. And if one wants to get a essential sense of where it is that one goes without figuring out exactly how one gets there, I would say that the functions are the ones that I mentioned in the libertarian state. I think it also has to deal with infrastructure and taxation. I think it has to deal with the provision of public goods. And I think it probably has to deal, though on delicate tiptoe, with the regulation and prohibition of various kinds of monopoly, or recognizes the real dangers that can take place when an administrative state starts to deal with that rather slippery subject. So you are now trying to look at a middle kind of a position, and the question is, how is it that you articulate it and defend it? Well, that's the first part of the thing. Now, the second kind of question is, how is it that we think about legal rules generally? And I'm going to try to be a little bit more of a lawyer and a little bit less of a political scientist for at least a minute. And here again, there are kind of three ways in which you can think about the law. I'm going to mention the two that I'm deeply suspicious of and try to indicate the third, which I think is much more moderate and sensible than either of the extremes. One of the things that's true when you're young in this world is that you believe that the class of deductive truths about social matters is rather larger than it really turns out to be. And so the great temptation of the strong libertarian thought, for which I was very, very fond and still have a lot of fondness for, was that somehow or other you could axiomatize it and sort of reduce everything to a set of principles which you can treat as either necessary or deductive truths of one sort or another. In fact, when you go back into the legal literature, you will typically find claims about the way in which social propositions are organized, which appeal to either the rules of logic on the one hand, or sort of universal physical principles such as Newtonian gravitational rules on the other hand. And in fact, you could go back and read Locke and Blackstone, in which the use of the word law is somehow or other deliberately equivocated so as to cover natural laws on the one hand, i.e. the laws of notion, and natural laws on the other hand, that is, rules of social behavior. And it seems to me that this is a very serious kind of mistake. If you look around to various kinds of societies, you see enough variety in the nature of the laws that if all of them are deductively required, there's going to be some kind of apparent inconsistency in the sorts of laws that we are going to have. In addition, it seems quite clear that there's certain degrees of evolution that take place with respect to various kinds of legal doctrine over time, and one would be deeply suspicious of how that could happen if immutability were the touchstone of the laws. And in addition to that, it turns out that whatever consensus we might have had about how legal principles ought to be organized is sufficiently shattered in modern times that an appeal to self-evident truth will fall on deaf ears by people who believe that the self-evident truths are manifestly otherwise. So I think that's one thing you have to be aware of. This is not a case in which there are going to be any cheap victories are coming out of a proposition that we can do by deduction or introspection or appeals to intuition and self-evidence the question of how it is that our basic rules of a legal system are organized. Now, that's one way, and then the other extreme, which I also want to avoid, is something which is more characteristic of the 20th century perhaps than the 18th century, but has had an enormous influence on modern efforts to undermine classical liberalism. And that's the idea that for one reason or another, virtually every proposition that you wish to assert about the nature of a proper legal order is necessarily infected with some kind of a fatal contradiction. One of the things that I did in preparing for this book was to read what I thought was the best study on critical legal studies, a legal movement which has this in mind, by Mark Kellman in 1987. And it's very clear that there are more contradictions within the framework of capitalism on 2 pages of that book than there are in any logician's manual. At every single point, when you start to deal with the kinds of problems that are faced, it turns out that you discover that contradiction is what dooms you, so that the critical legal types in many ways turn out to be the mirror image of the natural law types. They assume that if you articulate various kinds of propositions, you can show not their necessity, but rather their impossibility. And again, it seems to me that they are wrong for exactly the same kind of reason. Just as there are no cheap victories that are to be won by folks who believe in classical principles of individual liberty and so forth, so it is that there are no cheap victories that are to be won by their opponents. So then the question is, what on earth do we start to do when we try to figure out if we can find a middle ground? And it's here where one starts to think about skepticism and its relationship to freedom and its relationship to human nature. Essentially, as I've gotten older, maybe a little bit wiser, and that's why the 30 years really starts to matter, I have discovered to my infinite regret that most of the serious questions that you have to be able to resolve about the articulation of the basic principles of any political order have an irreducible empirical content that is associated with them. What you must be able to do is to figure out how it is that you can get a degree of generality in your understanding of human nature so that you can do 2 things simultaneously. One, to be able to articulate and to defend a general set of principles as to how it is that you think the world ought to be organized, and secondly, have a set of principles which is sufficiently respectful of why it is that your principles of social organization do not to the last jot and tittle determine what everybody ought to have, when they ought to have it, and how they ought to have it. That is, you have to have enough knowledge to allow you to establish a framework, and you have to be able to be cautious enough so that that knowledge doesn't allow you to dictate what the world is going on. There are, in effect, 2 forms of skepticism. There is a form of skepticism which says that we know nothing about legal rules and that cannot articulate anything, and that's a very dangerous form of skepticism. But the sensible form of skepticism says we know enough about the basic patterns of human behavior that on average we could figure out a set of rules that is going to do better by us than some of the alternatives that we might choose to develop. To put it in some of the rather fancy philosophical jargon that comes out in modern times, the intellectual conversion that I've undergone in 30 years has been to recognize a slight expansion in the scope of the state over my former libertarian self, and a rather radical, and to some people regrettable, I'm looking at Roger Pallone, conversion of my own intellectual beliefs, so that I tend to be somebody who's more of a moral consequentialist rather than a deontologist. What am I trying to do with this kind of position? It's essentially to see if I could give firmer foundations for a lot of the strong intuitions, not of the modern socialist, but of the natural lawyer, so that when one starts to deal with the issue, you can get beyond discussions of self-evidence and try to give something about real and material effects on human beings in ordinary social contexts as a function of legal rules. This makes me an ancient in another way. I mean, not in terms of my own age, but in terms of the way in which I think about legal problems. One of the things that has impressed me about all of the great classical writers on government and individual liberty is that almost without exception, they do not start with the question of political organization or the question of individual rights. Rather, they are much deeper in their instincts, and they start with the questions of human psychology, how it is that we think the basic tendencies of human behavior will work themselves out over time, and what we can do in order to understand these. So that the nature of society depends to some extent on this somewhat overgeneral and grandiloquent phrase, whatever the word is, about do we know something about the nature of man. And at the time that this was said, in earlier days, sometimes we didn't know all that much about the nature of man. And that what I'm trying to do in this study is to figure out a way in which we could take some of the basic instincts which are associated with evolutionary psychology or sociobiology or general evolutionary theory and see the extent to which they give us enough information to have purchase on the organization of various social institutions. And this means that we want to start with some very generalized styles of fact to see if we could then figure out what the main lines of our social institutions ought to be. What are the key features of the system that we ought to talk about? And it seems to me we could start with about three. One of these has to do with individual self-interest, the second has to do with scarcity, and the third is a refinement on the first, which starts to talk about why individual self-interest is in fact not quite individual, but rather has a rather more complicated cooperative nature associated with it under the name of inclusive fitness. So the biological stuff that I studied in the 70s and 80s comes back to haunt the legal work that I'm doing in the beginning of the 21st century. Now, why does one want to start with scarcity? Well, I think, in effect, that if there's one truth which we can regard as being self-evident, that's going to be it. If we look around the world, it turns out that there's a finite space, finite amount of land, finite amount of water, and it also turns out that the level of desires that we have with respect to these resources are always greater than the resources that are available to satisfy them, no matter what the state of humankind. At that point, even before you get to the question of how legal rules intervene in the operation of a political system, the question you have to then ask is what kind of personality types are going to be able to survive in an unstructured environment where, in fact, scarcity is the dominant constraint. And the answer is there's going to be one kind of characteristic which is going to dominate over all others, and that turns out to be self-interest subject to the qualification of family and inclusive fitness that I mentioned. So let's just kind of lump those two things together for a moment. Let us just assume in a hypothetical experiment that you have two kinds of folks, some of whom have been benevolent and indifferent to their own welfare relative to that of their fellow man, and others who turn out to be egotistical. If you run this sort of necessary experiment, what's going to happen is one guy is quite happy to have a 50-50 split, and the other guy is going to end up with 75-25. Over time, the self-interested individuals are going to manage to co-opt more and more of the resource base. What has happened to more and more of the resource base which is otherwise made available to them? I guess there's somebody who truly disagrees with everything that I'm about to say, that the resource base is going to be necessarily truncated in those directions. Selection pressures are therefore going to have an enormous bias in favor of the selfish with respect to those who are altruistic by virtue of the repeated and inexorable application of this same kind of shall we say, method of behavior. The question is, what's the brake on individual self-interest? And the answer turns out to be generic inheritance. It Basically, if you're going to try in this thing, if you're not in it for the long run and you simply want to gorge yourself on sweets and fancies, you can die out at one generation, at which point those people who are altruistic with respect to their own children will fare far better than those who are selfish in that regard. So the dominant feature that one has to deal with respect to this kind of situation is a theory of inclusive fitness, in which the definition of self-interest that we as individuals use is a definition which takes into account not only ourselves, but those people who are related to us genetically. Just this simple modification of the basic rule means that the strategies that individuals, who are of course the social actors, take are far more complicated than they would be in any kind of system in which we followed just the naive Hobbesian view that individual self-interest means the autonomous fellow. It also means that many of the classical critics of laissez-faire have a point which could be in fact incorporated into the system, which is the idea that you're going to assume atomistic individuals who care nothing about any sort of connections is in fact not an outgrowth of the theory that we're talking about, but is a direct contradiction to it. The level of cooperation that is necessarily required in order to implement the genetic program, therefore, can be a base by which you could form larger and more complicated social behaviors than might have otherwise had been. Once you understand this kind of a theory, it helps explain why it is that there's a way to get out of the Hobbesian dilemma without getting yourself into the terrible pitfalls of the absolute state. So the assumption that we're talking about here is enormously important. The next point that we have to make, which follows from these two, is how does the resource constraint and the self-interest work when it comes for dealing with things in the external world? And here, the basic biological proposition that I would want to refer to is a very simple one. It has to do with the fact that there are variations off a median in every population, and that these variations are necessary for survival. If every individual were exactly like every other individual, we would lose two enormous benefits. One is it would no longer be possible to have cooperation between individuals with slightly different skills, because in fact the gains that you would get from trade would be reduced very substantially by the identity of the kinds of individuals in question. And secondly, your ability to be attacked by external perils, for example, disease, would be markedly increased, because once you're the Dutch elm disease tree, you wipe out the entire industry, because in fact there's no variation which allows you to have certain degrees of resistance. But variation over what? And it's here I think that we can see some of the dangers of moral relativism. One of the words that we use in everyday language to describe the products that we can purchase in a marketplace is the term goods. And the term good is not just simply fortuitously related to the idea of individual good. Quite the opposite. The reason we tend to call these things goods is because we know on average that they are going to improve the fitness of those individuals that consume them, unlike wastes and bads, which are going to have exactly the opposite effect with the people involved in any particular case. And the reason we know that there is basically a distribution which is on the positive side and on the negative side is we know in effect that the sort of caloric minimums that is necessary for everybody to live creates a kind of imperatives that are jointly shared. So that what happens is we now understand essentially the basic explanations as to why it is that people need territory, which then becomes property, why people need bodily integrity, which then becomes the principle of autonomy, why people need to cooperate in order to expand their possibilities, which becomes the principle of contract. The question then is, how do we start to explain this in other kinds of terms? Well, here we have to have an objective theory. What is it that we're trying to achieve when we start to impose laws? And simply to talk about this as though the sole object were individual liberty as an end in itself misses the very important question of whether or not the actions that one individual creates will have systematic negative consequences with respect to other individuals, and if those negative consequences do occur, what, if anything, should be done in order to counteract them. And so now what you do is you start to put all this stuff together, and it starts to give you some indication of the way in which the basic system is going to start to fit. And the first thing that you start to note is that the autonomy principles are extremely strong in any legal system, because the moment you allow somebody to break the bone or to penetrate the skin of another person, then death is going to be the consequence on one side through infection or exhaustion or bloodletting or whatever it is, and the gains on the other side are going to be relatively small. And the great insight of all the social contract theorists is, to the extent that you engage in the mutual renunciation of force, we are confident, given the commonality of our human origins, that all of us will gain more from its relaxation, or from the imposition of this prohibition, than they will suffer from being bound by it. This is not a necessary truth. It is something which you could deny, but it is not something I dare say that you could deny with a straight face. And the great reason why it is that social contract theory has always tied in with general utilitarian theory is one of them sort of talks about a method of hypothetical exchange, and the other starts talking about the gains that real exchanges, and by definition, hypothetical exchanges, ought to achieve. So much of the utilitarian tradition and the social contract tradition are finding rather different ways to express what is called the same fundamental truth. This then gets pushed on because when you're dealing with these duties of non-intervention, the only way it turns out that they will be effective is to be universal. It does me no good to say that old Pallone can't snipe me because he disagrees with my political theory if it turns out that Bill Niskanen can take up the cudgels and do the job for him. What is essentially critical in all of these cases is that unless you have absolute unanimity with respect to the principle, your worst enemy will be the one person who will do you in, and the gains that you get from everybody else will no longer suffice. So that what happens is, since we know that actual contracting is not possible, this becomes the absolute universal social imperative. Non-intervention, enforced in some method, which we'll talk about in a moment, has to be something that we want. Whatever the variations that we have amongst ourselves as individuals, if we don't follow with this particular kind of requirement, we're not going to succeed with anything at all. Now, the next question is, how do we take into account the variations? And here there's a very powerful legal parallel. Generalized rules in rem that is good against the rest of the world tend to be negative in form and universal in application, easily observable. They are rules in effect that work no matter how large or small the population is. So whether you're talking about Rome of 1 million or the United States of 300 million, the same negative rules can apply perfectly well to the large number of situations you face. But as I've also indicated to you, there's a power level of individual variation. And the question is, how is it that we try to exploit that? And we have basically a one-word answer. We try to exploit that through exchange. And the basic theory here is as follows. As a structural matter, if you're having voluntary exchanges, you could be confident that the 11th commandment, the one they forgot to write on Sinai but should have written there, will apply. And it's one which has been beaten into my head for 20-odd years, and I'm going to say it again, is that voluntary exchanges result in mutual gains for the parties. So that what happens is, the presumption is, and I use the word presumption here very advisedly, that the mutual gains from trade are the things that make contract go. Now, the important thing for these purposes to note about this general proposition is that the reason that these kinds of contracts make things go depends only on our general knowledge of the bare features of human behavior. It does not depend upon our knowledge of whether or not you like carrots or whether or not I happen to be allergic to broccoli. And so what the system says is, in effect, is this. We know about these variations, and the reason why we have private ordering with respect to voluntary contracts is that the private knowledge that people have about their own preference structure is essentially superior to any collective knowledge that people have about preference structures writ large, and so that the whole point of the system of the privatization of contract is to make sure that the gains from trade which are otherwise available are achieved, and that can only be done by exploiting the private information. And the genius of the legal system is it doesn't have to know what the private information is in order to be able to validate the information. All it has to know is that the preference maps of different individuals at different times are not identical to one another, so that gain from exchange can produce improvements in welfare, and that those improvements of welfare have the following additional characteristics. One good idea applied 1,000,000 times is an idea which generates 1,000,000 gains. As Robert Nozick, my good friend, and I think a lot of good friend for a lot of people here, emphasized when he talked about the redistribution and his rules of transfer, is that whatever you receive in one set of transfers, you can use and bargain in the next set, so that the recursive nature of the exchange principle allows you to get incredibly complicated forms by the successive application of a single given idea. And that in turn informs what becomes the major exercise in the law of contracts, which is how it is that you reduce the transactions cost associated with these transactions so as to maximize the velocity of exchange. And in some cases it may require formalities, in other cases it may require their elimination. But the basic technique is there, given the objective which comes out of what it is that we have. Now, the libertarian prohibition on force and fraud, of course, is done for exactly the same reason, going in reverse. Given our confidence that if you can do something voluntarily, it's a mutual gain, we start to have very deep and profound restrictions that any time you use force or aggression against another individual, it's a victory to you, it's a loss to somebody else. We know it's not a Pareto improvement, and most of the time, we don't believe that it's any kind of improvement at all. We tend to think that the losses are enormous and the gains are very, very small, and that's why we have the prohibition on the use of force and the use of deception. Deception's a little bit more complicated than force, but essentially the basic argument is that when people lie, what they do is misrepresent the relative value of two things in exchange so that the victim in question is going to turn out to be a net loser from the exchange in question. Now, what I did in effect is I said that these things are presumptions, and it's extremely important to explain why it is that the presumptive language has to be used in here, and it's another form of skepticism. If you are really confident about everything that you say, you don't believe in presumptions. You tend to believe in absolutes. And whenever you believe in absolutes, what happens is you come up with cases that seem to fall within the principle, but by God, when you look at them, they seem to require a cry out for treatment in the opposite direction. And one of the great weaknesses of standard libertarian theory is that it tends to push too hard on the presumptions to make them into absolutes and doesn't have any coherent way of trying to figure out what the counterexamples are and how they ought to be resolved. So what I'm going to do is to just talk for a minute or two about the way in which one ought to deal with these kinds of presumptions. Let's first start with the one about voluntary exchange. Is there any kind of circumstance in which an exchange that is voluntary ought to be distrusted? Well, in the usual case, the answer is no, because most of the externalities to the transaction turn out to be positive rather than negative. If it's an ordinary contract for the sale of goods and both the buyer and seller benefit from them, each of them has a larger resource base, which in turn gives greater opportunities to trade for third persons. The only externalities you have are positive, and even though those are not formally acknowledged in the legal system, it's another additional and strong reason is why it is that you don't limit the contract. But on the other hand, if it turns out our contract is to kill a third person, now the externalities are positive, and the mere fact that there are gains from trade spell greater peril to the third party. And so once you have the third party, immediately your attitude towards contract has to flip over. These are no longer contracts for exchange. They're now conspiracies to commit murder, contracts for aiding and abetting, and something of the sort. In other cases, slightly more removed, when you start dealing with antitrust type situations and monopoly, I think the classical theory is strong enough to suggest that the gains to the insider from comparison are smaller than the loss inflicted upon third party. So we don't call those contracts anymore. Now we start to call them cartels and collusive arrangements of one sort or another because of the intuitive appreciation of what's going on. The great office of antitrust law, the great office of regulated industry is, can we have the institutional wherewithal to distinguish between those positive sum contracts and negative sum contracts, or when we put it in the hands of judges, where are you, Steve? Are you going to systematically get it wrong such that the contracts you enforce have negative consequences on third parties and the ones that you strike down have positive consequences? And the great antitrust revolution of the last 40 years has been trying to get the sign right on those things, and I think for the most part has done a tolerably good job. What about the other situation? When you start looking about the presumption against the use of force against other individuals. One of the things that libertarian theories have always had a very strong difficulty with has been with cases of necessity. And the classic illustration is, can I break into your cabin without your consent in order to prevent myself from being killed in a storm? Can I do so even when you try to resist my entry on the ground that it's your property and you have a quote-unquote absolute right to exclude? It turned out, again, much to my happy amazement, when you actually looked at the common lawyers, they were more sophisticated on this question than the academics who are writing about them. Blackstone said it, Pufendorf said it, Grotius said it, they all said it, which is that essentially there is a suspension of ordinary property rights under conditions of necessity. And that meant, in effect, that the outsider could become the insider, and when the event was over, he'd have to pay compensation for the loss of use or for the dislocations that were treated. It became, in effect, a taking with just compensation. This is not only important with respect to those odd cases of necessity, where many people will relax and let the guy come in anyhow, no matter what the law says. That's certainly been the practice in maritime cases. But this becomes the paradigm in a situation where you're dealing with the eminent domain problem, where property may be taken for public use upon the payment of just compensation. The difference here is that the necessity is no longer one of immediate survival. Rather, it's the question of coordination of social resources in such a fashion that you could put together a highway when otherwise the holdout problem would be very severe. This, in fact, seems like a small emendation of the basic libertarian theory, but in fact it's an enormous kind of modification. And it's one, I might add, that has good constitutional sanction. Because the moment you start to put the form in this particular fashion, then what you have to do is to figure out exactly how it is that you are going to ensure that the compensation required is going to be paid, which particular forms of ventures ought to be taken and which ones ought not, what counts as a trespass upon another individual and what does not, and the entire sprawling takings law, which for the most part is largely chaotic in the United States, has to answer to the question of can you meet the justifications that we need. Namely, can you find yourself a situation in which coercion, when imposed upon an individual, works to his particular advantage in the individual case, so as to avoid the argument that coercion and aggression are side by side. To put it in slightly more technical terms, the standard libertarian figures out what you're trying to minimize in the social welfare function is the use of force and fraud, but somebody who understands that the takings issue is an important one now is trying to minimize two sorts of defects that cut in opposite directions. One of them is the coercion risk and the other is the holdout risk, and it turns out that the moment you try to control one, you increase the other, so the maximization game is rather more difficult than it would otherwise be. And figuring out what the optimal systems of taxation and the optimal systems of regulation are requires you to solve that incredibly nightmarish problem. Can you do it? I think the answer is that you can. I wrote a takings book and a bargaining with the state book in order to do it. I'm not going to try to go into the details here. I'm just trying to point out what the agenda starts to look like. Now, the second problem that one has to face is if you've got all of these normative theories, do you have a government that can enforce them? And one of the things that one has to recognize is that the rights that we're talking about are hypothetically improvements over a state of nature in which none of them are observed, but one has to be able to develop a comprehensive system of public institutions that can finance the protection of the rights that have been created. And here the optimal theory of taxation is not zero taxation, nor is it a theory which says that you could do whatever you want. The question here is not how taxes preserve liberty, which they do to some extent, but what's the optimal theory of taxation so that we know how many taxes you could have, what their incidence and their distribution ought to be. It is interesting on this particular question that all careful libertarian type thinkers have come to the same conclusion, which is they are strongly in favor of proportionate taxes, they are deeply suspicious of head taxes, they are deeply suspicious of progressive taxes. And I think the reason for this can be summarized in one or two sentences, and I'll leave the elaboration for another day. What is advantage about the proportionate taxation system is that it places no dollar amount on the amount of money that the state can raise to discharge public functions. So that it's not as though in time of war you're going to have low taxation when the survival of a nation is at stake. But what it does do is it places a limitation on the distribution of the tax so as to be able to avoid or to limit the political rent-seeking that takes place when everybody tries to get a very large share of a public benefit, but to push off the cost that is borne by somebody else. In some circumstances, it turns out that general taxes are not appropriate because of the skewed nature of the benefits. And one of the things that the 19th century lawyers understood and the 20th century lawyers have forgotten is that the principle of matching costs and benefits lie at the heart of any system of special assessments, and that to the extent that you allow special assessments without a matching principle, it is simply a massive road to factional intrigue. So my favorite case decided to me by Guido Calabresi was there was a question of how it is that you decided to tax for a road on the basis of front footage of the nearby properties. But it turned out for 30 miles the road was bordered by a railroad which is in direct competition with it, and the question was whether or not the railroad benefited from the road that it had to pay for half its cost. And the United States Supreme Court said of course it did, because the legislature said so. It was a complete breakdown of the way in which the system worked. Now, the question we want to ask, and I will end with this kind of discussion for about 5 or 6 minutes, is how does this translate itself back into constitutional law? That is, to the extent that you really have a system of political design which indicates the things that you ought to be able to do and the things that you ought not to be able to do, tries to give you fairly bright line rules as to which are acceptable and which are not, recognizes that there's some marginal cases. How does it translate out? Well, essentially, this is a tale of two sorts of doctrines. One of them, and I will lump them together for these purposes, is the question of looking at constitutional guarantees either under a strict scrutiny or an intermediate scrutiny standard, which are fairly close together in many cases in a practical sense. And then on the other side, starting to look at things at a rational basis test. And the basic proposition that I'm going to take to link the political theory to the constitutional law is if you start down the first road, and take seriously the constitutional guarantees, in almost every case you're going to come up with, if not the right answer, at least a reasonably good approximation thereof. But on the other hand, if you decide to start down the second road and assume that rational basis is okay, you mean exactly the opposite. What you're really saying is that if you believe that 2 + 2 are 5 and you're willing to swear to that before a legislature, then in effect, everybody with a computer is forced to agree with you for the purposes of the legality of the statute in question. That is, to some extent, the position that Bob Bork has taken, and why it is that it turns out the American Enterprise Institute has to be a very broad umbrella to take into account the different brands of conservatism or libertarianism that lie underneath the tent. I happen to be a consistent believer in the first view, and a deeply suspicious of the second. And if you look at First Amendment law, I think the wonderful opinion which illustrates how to get the skepticism right is, in fact, our friend Oliver Wendell Holmes writing in dissent in the Abrams case, when he starts to talk about it, when men have come to realize that time has upset many fighting faiths, they will realize more than they hold their own beliefs that the best test of an idea is ability of itself to get accepted in the marketplace. And what he basically meant by this is, before we start to coerce those individuals who turn out to be dangerous against us, we have to be damn well sure that they pose an imminent peril to our own safety, by which he meant quite precisely that there has to be the immediate threat for the use of force. And essentially what happened is he developed, in conjunction with the First Amendment law, a replication of the common law rules on injunction, which says that you hold back against injunction unless there's an imminent peril of a serious danger, on the grounds that otherwise damages after the fact will be adequate for the circumstances at hand. And of course, he got it right, because he didn't say that this was a rule of absolute necessity or self-evident truth. He made a judgment that this was the best test of whether or not there's truth in an idea, on the theory that voluntary exchange in ideas, which, by the way, is a more complicated market than voluntary exchanges in goods, is in fact the only way in which we can work, unless we are going to pre-commit ourselves to the belief that some set of goods are bad and some set of ideas are good. And he just didn't believe in that pre-commitment. But what we necessarily have to say is we have enough knowledge about the dynamics of political debate that we are willing to treat the proposition on freedom of speech as a strong enough regularity that we're going to embody it in a constitution. And once we decide to do that, it's because of exactly what I said before, is that we know enough about the regularities of human behavior to be deeply aware of the use of coercion on political dissent, even if we don't know enough to know which set of ideas turn out to be right or which ones turn out to be wrong. And essentially, if you go through the First Amendment, it turns to follow a fairly close classical liberal handbook. It turns out, therefore, that the heads of major intervention are the threats and use of force, the threats of use of fraud, and also the whole question of what kinds of taxation on various kinds of speech-related enterprises are permissible with respect to speech. And they tend to be flat taxes and proportionate, non-discriminatory regulation. A classical liberal synthesis created by a group of judges in complete ignorance of the classical liberal synthesis that I'm talking about. That is, they managed to get it right through case-by-case adjudication without any strong intellectual pre-commitment to the system as a whole, and indeed in many cases with deliberate antipathy to the system as a whole. Now, this guy Holmes was a very elegant writer, and he wrote another case, and that case was called Lochner against New York. And here what he said is, in effect, if the state wants to pass a statute which limits certain kinds of bakers to working only 10 hours a day, it's just a question of political will one way or another. And he says, and I quote, that the idea of liberty will be perverted if it is taken to mean anything other than the ability to walk around on a public street without consent. Now, notice this is typical Holmes. Perverted is the word that he uses to describe the liberty to marry, the liberty to religion, and to pray to God in your own way, the liberty to enter into voluntary exchanges with other individuals, the liberty to give testimony, to make a will. It's a perversion of the idea of liberty to talk about all those things. It is ironic that the people who understood the non-perversion of these conceptions are people who are universally reviled today because of their narrow understanding of the mainsprings of human conduct. And I refer to those two great heroes, Justice Justice Rufus Peckham, who gave the broader definition against which Holmes was regaling in the Lochner case, and then it turns out to be Justice McReynolds, who tried to use exactly the same kind of definition to make sure that parents who wanted to send their children to private schools were not swept up by a government craze into public institutions. So let's just understand what the origins are. Now, if you take the Holmes position, it turns out that, in effect, any kind of justification the state puts forward is going to be okay. And so in the Lochner case, where you have something which in fact looked like a very powerful piece of class legislation, which indeed was the ground on which the statute was attacked by the lawyers who attacked it, his attitude is, I can't figure any of this stuff out. I don't have any general vision of a way in which people act in the legislature. If the dominant opinion wants it, it is justified on the score of health. And it's only a shibboleth of laissez-faire which goes in the opposite direction. It is worthy of note that even though he had these rather iconoclastic views, not a single other justice on the United States Supreme Court at the time shared his opinions. He was, and should be understood, not as the harbinger of the future, but as a renegade from our constitutional tradition. Now, how do we know that? Because he said, our Constitution makes no commitment to either laissez-faire on the one hand or to the idea that there's an organic relation. It's a very dangerous term for all of us future fascists, an organic relation between the individual and the state. Contrast that with what he said in the Abrams case, where we've staked our all on this experiment that free trade in ideas are what does it. Well, why not free trade in labor unless there's some reason why it is that we ought to oppose it? Why do we want to fractionate the inquiry when in fact we have a theory of freedom which covers not only speech but also contract and covers the two of them indifferently, that is, in exactly the same fashion? The great mistake of modern constitutional law with respect to individual rights, whether it be with occupational freedoms or with takings, is the assumption that a theory which is good enough to explain how it is that we work in First Amendment areas is utterly worthless and completely contrary to sensible facts when we are trying to work with other areas of basically individual activities associated with economic behavior, property rights, or the sort. The great battle, as far as I can see in constitutional discourse, is whether or not we can persuade ourselves that the principles of classical liberalism, which have very deep and powerful roots, are strong enough to allow us to organize our Constitution. Because recall, our Constitution is not a pure libertarian doctrine. It does recognize taxation. It does recognize the power to condemn. It does recognize the ability to overcome collective action problems. It meets all of the standard devices that we had to worry about, did it intuitively. And the great tragedy of, I think, modern jurisprudence, for which I hold some but not all judges responsible, you're exempted, Steve, is in fact that they had the heritage handed to them on a silver platter and they managed to throw it away. Thank you. I'll take a breath. Does anyone have a glass of water, by the way?
They're right on the podium.
Oh, on the podium. Hey, go ahead.
Richard, what is the role of skepticism in your argument? Aside from the reference to Holmes and so forth, there was no...
Oh, yes, no, I thought I said it, is that what we have to be skeptical, essentially, is our ability to have knowledge about the gains and losses to individuals that we could legislate from the center what the terms of exchange ought to be. Because if we really think that the knowledge we have, which is strong enough not only to regulate the case for exchange, is strong enough to regulate the terms of exchange, then we have no resistance against subjective, right, from the centralization of government power and so forth. And indeed, in some primitive societies, you can make the argument that those at the centers had sufficiently powerful knowledge differentials on, what the means of production were, that they would offset whatever advantages people had on their own preference sets. I mean, that's a complicated argument. But the role of skepticism is essentially a role which starts to indicate we don't know enough about what people want to tell them what they ought to have. And that becomes the anti-paternalistic side. And the point of the regularity of the situation is that we know enough about the general tendencies to see the general positive sum games that come out of the voluntary exchange. So that's what the theorem is. And remember, let me just add one other thing. I hope in one deep sense there's absolutely nothing new in anything that I've said. The only kind of political theory that makes any sense is that which draws from all parts of the tradition and tries to put them together in a way that's a little bit different, which is traditionally done, so that you could start to see the connections and draw the best out of these various traditions. And I try to do that with the utilitarian and social contract tradition. I try to do it with the pleading tradition, which I didn't even talk about today, and I sort of try to do it with the biological tradition and the ontological tradition. You try to get it all together, and the job is, everybody's got the notes out there. Your view is to figure out if you could turn them into a nicer melody. Okay, any other questions? Yes, John. Oh, my God, a lot. Nothing is new. What's up, John?
You talked about externalities in terms of force, but how about externalities in terms of preferences? Is it simply that once you open up that can of worms that, because surely in terms of the wealth maximizing principle that you talked about, surely to some extent that's going to be taken into account.
Well, absolutely. This is another long part of the discussion, which I don't have here, but which I do try to talk about in the book and elsewhere, which is what's the appropriate definition of an externality, which deals with the question of regulation, right? I mean, I think that's the problem that you're asking. And here, in a sense, what happens is there turn out to be a large number of externalities, which in the long run average advantage, it is in everybody's interest that we ignore. And so if you start to try to figure out the way in which the force externalities profile themselves, it turns out that in a civilized society, thank God, they're relatively large in magnitude, relatively infrequent in severity, and to the extent that you want to stop those things, it's like getting the low-hanging fruit and keeping the things in order. The moment you start to switch to certain other kinds of externalities, i.e., you manage to practice a religion of which I am not a part and it duly offends me, we have to start to recognize that this is perfectly reciprocal. Unlike the use of force, it turns out that you practice a religion which offends me, and so now each of us has a complete case to ban the other. So what we do is we put people functionally behind a veil of ignorance. We say, if we're going to allow these kinds of preferences about external behavior to work for you, they're going to have to work for me. Are we better off, given enforcement costs and so forth, in recognizing these externalities in both cases or denying them in both cases? And I think when you run the mental experiment and make the empirical judgment, because these are all empirical judgments, it's going to be pretty clear that a toleration principle is going to beat the others. And of course, the ancient lawyers beat us to this. The expression that they used to cover exactly these kinds of cases, and also cases of competitive injury, same kind of thing, was damnum absquare injuria. It meant that there was a harm. You don't want to pretend that there's a theory of causation which sort of makes these things disappear. There's no necessary truth here, as with any other libertarian proposition, but without injury, in the sense that we now make a social judgment that these things are not going to be actionable. And economists start to call these things sometimes pecuniary externalities or various other terms, which again is designed to capture the notion that the simple fact that somebody is left worse off by somebody else's action is not in of itself enough reason to justify the imposition of legal force. And sure enough, if you start to look to the First Amendment, where again they actually care about getting it right for whatever reason, that doctrine is announced over and over again. So if it's a question about the flag salute cases, for example, the mere fact that large numbers of Americans are offended that the Jehovah's Witness won't sign up to the Pledge of Allegiance is no reason to coerce them into that kind of belief, notwithstanding the real harms the other way. Or the fact that many Americans are offended that certain people wish to burn their own flags is not enough under the First Amendment to allow it. So what we do is, in a consistent area, when you really care about liberty, you really care about the definition of harm. When you don't give a damn about the liberties, as in the economic cases, anything counts as harm, including competitive industry, so that every piece of reactionary statute on anti-dumping laws, for example, all use the definition of harm, offense to others, competitive industry, which are exactly rejected in the First Amendment area. So when you're talking about the differences in the theories, it runs really deep, all the way down to the absolute bottom. There is not a single issue which does not have an analogous problem in the two areas which get completely different solution. And one gives you legislative supremacy and the most god-awful system of intrigue, and the other gives you, in fact, a system of limited government, which turns out to be stable over 20 years. Now, why is that important? Because it goes to our friend Williams over there. So many people have said the problem about my system is no judge could ever do it. They're too stupid, too vain, too ignorant. I mean, judges even say that about themselves. My view about it is, how could they make that argument when they've already done it? in at least one area which is every bit as fraught with political difficulty. And even though you can find things that are wrong, like with New York Times and Sullivan at the edges and so forth, they basically got it 80 to 90% right. When you look to the federalism area, it's the same framework that applies with competitive federalism within the state, 80 to 90% right. When they don't try, 80 to 90% wrong. It seems to me it's worth the effort. Don't sell yourself short. I'm going to take another question from somebody else. Yes. Yeah, you. Here? Oh, well, I don't have, there are no property rights in this room. Okay. All right, Steve has got the microphone.
I have two questions. The first, there was one obscure point.
Only one?
And that was, what did Rex Harrison say?
It's a woman. She does precisely as she wants and does exactly as she pleases, living her life free from strife. But they said, let a woman in your life. Don't you remember? All right? So this was essentially the laissez-faire version of liberty that was driving him to distraction until he married it. All right,
then the other question is...
better be less serious than that
our
one.
Our Constitution says you only get on the Supreme Court after being nominated by the President with the advice and consent of the Senate.
Well, I basically have committed suicide for that.
but for an Epsteinian court to come into existence, doesn't the political atmosphere have to change so drastically that in fact such a bunch, even applying rational basis, would come out right?
I think the answer is absolutely correct. I mean, I do not.
Once you win it politically, it doesn't matter so much.
Oh no, it does matter.
How stupid the judges are.
No. If you win it politically, you will win it for a short time. You'll have a Gingrich revolution that will work for 6 months, and then it will start to decay again. The theory about this. That's a different question. I mean, the question of how we get this implemented, given the current state of affairs, the answer is quite simply. Not that you win, regrettably, you lose. I mean, we can get you on the court, which is a start, I mean, at least on the thing, and frankly, you're much more faithful to these principles than you would otherwise acknowledge, but that's okay. You don't have to confess. I don't want to have an impeachment hearing brought in the short run. But no, I think the serious point about this is the reason we engage in political debate is not because in a large society we get transformations of a sudden nature based upon a nice theory by a single person. But what happens is it influences the climate of opinion, and if you have a large and complex society and you could move things 1 or 2 degrees, all of a sudden, if I'm right, then when people start looking at Chevron deference, they defer a little bit less to an administrative agency, and then you start striking down some various things, and in the takings law, all of a sudden, defenses that used to work fail, so you get Palazzolo, for example, which comes out the right way to the horror of large numbers of people. And it also means that when you get in the political debates, you can now articulate a set of principles that aren't so utterly crazy that people on the other side could win by ridicule. I mean, the number of times, oh, you're a libertarian. This was told to me today by John Echeverria. You're a libertarian, so you don't believe that the polluter ought to pay with respect to tort damages, right? I said, why do you think that? He says, because pollution isn't a nuisance. I said, where did you get that? Because it comes from many sources. What about a class action? I mean, it gets absolutely crazy. And slowly but surely, the point of having intellectual discourse is that ideas have consequences. I'm not trying to get any once-time revolution. I'm not running a coup. But so long as I'm willing to take the abuse from people who aren't my friends, maybe I'm willing to hear a little bit of compliments from those who ought to be. That's the only thing that I'm saying. All right, Roger, oh my God. Hold on, Roger's going to throw me a cream puff. Come on.
Back to your principle of necessity, Richard.
You don't like that, Roger.
No, in fact, your earlier allusion was to my earlier writings, which, like yours, were more ambitious than the evidence warranted.
I don't get it, but...
You had that coming, Rich. In any event, the principle of necessity, as you know, that's ordinarily or ideally accompanied by a rule of subsequent compensation.
That's right.
And it is not used invariably. It is not used, for example, for body parts.
That's correct. And the
bifurcation is what concerns me there, because, of course, there is the analog on the social level with Caroline Products footnote 4, the bifurcation of the Bill of Rights, and so forth. And how do you keep if you're going to use these elementary principles of individual exchange from serving as models for subsequent social decision-making, whereby we distinguish, oh, it's okay to take property because that's only property. And then you have your usual First Amendment economic liberties, bifurcation. How do you keep that from slipping
One
away?
of the things that you start to do is you go back again to the common law rules, and sometimes they're very instructive. Under circumstances of necessity, the common law rules, which I think are the right norms, never required you to expend your labor in order to assist another. What we did is relied on a principle of voluntarism to do that, and one of the reasons we did is that we didn't want to get people into the possible situation that once they started, they get themselves into big trouble. And we know, for the most part, in the 19th century, the level of voluntarism, if anything, may have been excessive relative to the risks in question. That is, people would do so much to try to help folks that was never an issue. And I think that that's really a very accurate description of the level of cooperation that took place. When you're talking about proper necessity, the rule would only apply with respect to the use of somebody else's property. And if the dock was there, your basic judgment was that the implicit influence that it might have had on prior decisions of whether or not to build would be so negligible that there'd be no distortion with respect to the conduct in question and no danger of actually exposing some other person to bodily injury of his own. So that what happens is the only duty that you as the dock owner have when the other fellow is coming up is to step aside. It is not necessarily to give assistance. This is not a perfect rule, but in a rough and ready world, it certainly captures the anxieties. Now let's go back to the body parts case. This is the famous illustration of Judith Jarvis Thompson in a thing that she wrote on necessity in the 1985 Yale Review and Yale Law Journal, maybe somewhere else. And she says, look, you've got yourself a situation where you're driving a truck, or trolley is what she said, and you're on a track, and there's a siding to the right, and you discover that the brakes, in fact, fail. And now you can either turn to the right and kill one person or go straight ahead and kill five. What do you do? Everybody turns and kills only one and saves five, and assume they're all workmen. Now, she says, a patient comes into your office, and it turns out that he's a healthy patient, and you've got five people, and it just so happens, this is the just so world, that if you dismember this person, you can give one organ to each of these five people and save 5 lives. Do you do it? And well, the first thing you know is it doesn't pass the giggle test, because I saw Steve laugh, and the answer is you don't. Well, the question is, why not? And to a great philosopher, she couldn't see the difference because it was both a trait of 1 and 5. But the answer is crystal clear. It says that, what are you trying to do with respect to antecedent conduct? If, in fact, you impose the liability on him for hitting the 1 or the 5, he will minimize it and, in effect, will take antecedent precautions to avoid both, so that the long-term incentives that you create by the imposition of liability will get you as close to the optimum as you possibly can. The long-term effect of the other rule, if we announce it, is the end of the medical profession, because no healthy person is ever going to go in there. And at this time, we can start to see empirical differences between the two kinds of rules. Now, Judith Jarvis Thompson is a very brilliant philosopher, but it's exactly the ignorance of the way in which legal rules tie into behaviors over 2 periods, a standard economic question, the trade-off that you have between the gains you get in the first period and the losses in the second. The inability to see that as a serious kind of social issue leads you to state things that are laughable, and the reason they're laughable is because the deep structure of our trade-offs, which is our major things, says this is just very, very bad. So what do? You try to organize structurally a voluntary market for organs exchange. Is it going to work? It will do maybe a little bit of good with respect to kidneys, but only if it's above ground, because it turns out if you actually, and this is something I do know something about actually, if you're trying to organize an organ market, one-to-one exchanges are absolutely useless because of all the matching difficulties. You have to have a network. The only way you could get a network is to have an intermediate and a broker and to pool the organs and to pool the people, and that can only be done if you have legal enforcement of the full set of arrangements. Would you get a lot of buyers? Yeah, you get a lot of buyers. Will you get a lot of sellers? No. Because it turns out that there's a risk to sacrificing a kidney even if it's done perfectly. And I don't want to go into all the gory details of what could go wrong when it's not done perfectly. So in the short run, we should allow this. It will do a little bit of good. In the long run, what do? We better get ourselves a better system of animal technology so we can use pigs' organs to replace the kidneys. And if we do that, at that point, we will solve the problem. And the point about necessity is we don't want to talk about global necessities for organs as being the same thing as an immediate instantaneous necessity, which means that this guy has to go on this dock. And so it's the equivocation in the term, which is certainly sensible enough in terms of getting a program, which means that we have very different responses. One, we have the time frame for institutional response, and in the other case, we don't. Now, I know there's a question over here. Yes, and we need a microphone.
What do you consider currently the greatest threats to the First Amendment? Would it be religious expression in political campaigns, or religious expression outside abortion clinics, or could it be campaign finance reform?
Oh, I mean, you know, the First Amendment's a pretty big subject, like the Takings Clause. I think the biggest threat to First Amendment is none of the particularist notions, but rather exactly the opposite. There are many fashionable academics who start to believe that you really can't believe in freedom of speech because the inequality of resources are such that you have to have an extensive system of government regulation to make sure that there's parity in the marketplace. In other words, what they do is they say, oh, yes, we do believe in the marketplace of ideas, and we think it ought to be subject to the same regulations that are now permissible in the marketplace for goods. And if that starts to come in there, everything's going to fall into place at once with the change in attitude. Yes, you will have all sorts of campaign financing based upon arguments of fundamental asymmetries in market power driven by differential abilities and wealth. And you are going to have limitations on the ability of people to speak in political areas because of the incompetence of the audience that listen to them. And you are going to have vast restrictions on commercial speech because everybody knows that to tell the truth really is to tell a lie because the audience is so stupid that it can't understand. And all we need to make this thing really go south is the idea that we take over the rational basis test based upon this view of human nature into the area of speech. Is it happening? Well, I think for the most part, probably not. And I think that the justices have kept the line reasonably good. But it's sort of something which is very worrisome because inside the academy today, it is very clear that the civil libertarians' view of speech is actually in a minority relative to the regulators. My favorite illustration of this is my colleague, very esteemed colleague, Cass Sunstein, wrote a book which is called Free Speech and the Free Speech and the Problem of Democracy, is that what he's, or Democracy and the Problem of Free Speech. The title belongs the other way. It should be Free Speech and the Problem of Democracy. That is, the real danger is that of politics overwhelming freedom. It's not the danger of freedom overwhelming politics. I mean, it's that kind of trade-off that one really has to worry about. Look, the basic proposition is this. In its own unconscious ways, general philosophical propositions permeate particular decisions. And just as it happened with the harm issue that we were talking about in speech, it happens all the way through. It's not that anybody is smart enough or dumb enough perhaps to figure it all out. That's our academic job. But lawyers, even if they don't have it in the abstract, they instinctively know which position they take in the concrete case. And so their ability to carve a comprehensive system by pieces is far greater, I think, than is sometimes appreciated. When do you want me to call it a day, my friend? Like now?
I'm going to thank you very much.
Okay.
Richard Epstein is a law professor at the University of Chicago and author of Principles for a Free Society, Property and Freedom, and Mortal Peril. His forthcoming book is called Skepticism and Freedom, a Defense of Classical Liberalism, and it will be published by the University of Chicago Press. You can visit press.uchicago.edu to get more information.
Force and fraud. And there's no question that there's a great deal to be said for the affirmative case there, that you have a government that does at least those sorts of things. But it seems to me on end that it will not be able to account for many of the common features of our ordinary organizations, and that we therefore have to bolster the theory. So, for example, it is generally accepted that we have a system of taxation, at least some system of taxation that's going to be appropriate. It's also clear that the government seems to have some role in respect to the sort of the supply of various kinds of social infrastructure, and neither of those two functions fit very easily within this particular framework. So the question now is, how do we make government a little bit bigger than us sort of small-time libertarians would like it to be? And it's painful to me to recognize that we have to go that far. And one of the reasons why it's so painful is that you might end up going a great deal further. Because one of the tendencies on the other side, which I'm equally anxious to avoid is the position which says, since you cannot give yourself a narrow and limited definition of what government does, essentially what you have to do is, in constitutional and political terms, is to recognize that the state that you have can do more or less anything that it pleases, so long as it gives at least some nod to advancing the common welfare of the good of the population at large. But that any kind of intervention, regardless of its particular social program, is, if passed with that kind of benevolent motivation, going to be sufficient unto the day. And this, of course, travels under many versions. At one time, it used to be the sort of the socialist ideal that we could figure out how to have ideal distribution and ideal production just by ringing the various kinds of price indicators through central planning. I'm happy to say that a guy named Hayek got to that issue a little bit before me, and was able to explain, I think in fairly powerful form, why it is that that form of centralized planning doesn't succeed in the terms that it advances the argument, namely that it isn't able to produce the kinds of productive outcomes that we'll have. Mr. Khrushchev did not bury us. It turned out that the Soviet Union disintegrated under its own weight by the late 1980s and the early 1990s. It turns out, however, advocates for larger government are a very hardy breed, and in many cases they will now take more modest positions. And the one in which I think there's been a great deal said in this country is, of course, for the sort of...
I ask you all to join me in giving Richard Epstein a warm welcome.
It is very nice to see so many nice friends here, and many of whom go back for the 30 years about which I've been thinking about this and other kinds of books. If this were a crowd which wasn't so friendly, I would actually take the book out and try to read it to you in the 35 or 40 minutes that were available to me. But I somehow or other thought that I should take an alternative course of action, which is to try to jump from peak to peak, running the serious risk in an exposition of this sort that I might fall into some rather deep valleys, which I will leave unexplored in a talk of this particular sort. My view is I'm supposed to go, 35, 40 minutes? I don't know the drill. And then take the questions, and of course in the questions I will manage to remedy all of the serious defects and omissions that I've made in the talk. Now, and I was trying to figure out how it is I was to try to position this talk. I said, I'm now at AEI, and so what I have to do is to assume an air of reasoned moderation in which I manage to imitate the good and strong intellectual and corporate culture which has dominated this place. And so what I'm going to do is to try to describe all the kinds of ways in which this book, in fact, makes me Aristotle's main man of the 21st century. And the first of the kinds of, shall we say, moderations that I wish to talk about in this book is to indicate to some degree the sorts of substantive positions that I'm trying to avoid, and then to try to tell you something about the methodological traps that I am trying to avoid. And of course, the appropriate strategy with respect to both of those things is to show that there's somebody to your left and somebody to your right, so that you, in fact, have the virtues of the golden mean. And when you're trying to figure out what the substantive positions are that you are having to deal with under these things, one of them is, in fact, a position to which I have a great deal of affection. It's what you might want to call a stripped-down version of the libertarian theory, very powerful visions of the minimum state, in which the essential proposition about government is that its sole force is to avoid harms to other individuals, where harms to other individuals are going to be described in the narrow terms of the prevention of force.
Now, from the American Enterprise Institute in Washington, D.C., author Richard Epstein discusses his forthcoming book, Skepticism and Freedom, a defense of classical liberalism. In it, the author argues that America's current legal system is based on property rights, freedom of contract, and limited government. This event runs an hour, 5 minutes.
Richard Epstein is one of the great legal scholars of the age, and one of the great expositors of the principles and institutions of individual liberty. In addition to a copious literature in the law journals and magazines and journals of general circulation, and a long tour going back to the early 1980s as editor of two of the great academic journals of the time, first the Journal of Legal Studies and then the Journal of Law and Economics, both at his home, the University of Chicago Law School. He is the author of a string of highly important books on healthcare, affirmative action, other issues, including most notably his recent Principles for a Free Society, Reconciling Individual Liberty with the Common Good, and his well-known book, Simple Rules for a Complex World. When I heard that Professor Epstein was writing a book with the title Skepticism and Freedom, and being highly impressed with the ambition and scope of what I assumed the book would be, I asked him how long he had been working on this book, and he replied, 30 years. I think that you can guess from the title of this book, which will be published by the University of Chicago Press this coming fall, that it is in many ways a fulfillment and an extension of much that has come before in this man's distinguished intellectual career. His lecture this evening is by that title. It will be a sneak preview of his upcoming book. And I
reduce everything to a set of principles which you can treat as either necessary or deductive truths of one sort or another. In fact, when you go back into the legal literature, you will typically find claims about the way in which social propositions are organized, which appeal to either the rules of logic on the one hand, or sort of universal physical principles such as Newtonian gravitational rules on the other hand. And in fact, you could go back and read Locke and Blackstone, in which the use of the word law is somehow or other deliberately equivocated so as to cover natural laws on the one hand, i.e. the laws of notion, and natural laws on the other hand, that is, rules of social behavior. And it seems to me that this is a very serious kind of mistake. If you look around to various kinds of societies, you see enough variety in the nature of the laws that if all of them are deductively required, there's going to be some kind of apparent inconsistency in the sorts of laws that we are going to have. In addition, it seems quite clear that there's certain degrees of evolution that take place with respect to various kinds of legal doctrine over time, and one would be deeply suspicious of how that could happen if immutability were the touchstone of the laws. And in addition to that, it turns out that whatever consensus we might have had about how legal principles ought to be organized is sufficiently shattered in modern times that an appeal to self-evident truth will fall on deaf ears by people who believe that the self-evident truths are manifestly otherwise. So I think that's one thing you have to be aware of. This is not a case in which there are going to be any cheap victories are coming out of a proposition that we can do by deduction or introspection or appeals to intuition and self-evidence the question of how it is that our basic rules of a legal system are organized. Now, that's one way, and then the other extreme, which I also want to avoid, is something which is more characteristic of the 20th century perhaps than the 18th century, but has had an enormous influence on modern efforts to undermine classical liberalism. And that's the idea that for one reason or another, virtually every proposition that you wish to assert about the nature of a proper legal order is necessarily infected with some kind of a fatal contradiction. One of the things that I did in preparing for this book was to read what I thought was the best study on critical legal studies, a legal movement which has this in mind, by Mark Kellman in 1987. And it's very clear the comprehensive welfare state, the kind of thing that we have today in the United States, which works with a greater success than socialism, but essentially takes the proposition that in dealing with general matters of economic regulation, there is no powerful side constraint of constitutional law or legal principle which prevents the legislature from doing exactly what it pleases and exactly when it pleases to do this, so that Rex Harrison's versions of what the My Fair Lady ought to be about seems to be much of the modern political theory. Now, in dealing with this, I'm actually a moderate, because I do think, in effect, that one can escape the dangers of being the hardline libertarian without going into a position in which comprehensive government action is the order of the day. And so the subtitle of this book, which I added when I realized that no one would figure out what the title meant, was, in effect, a rather simple observation that it was a defense of the classical liberal position in which there are relatively limited kinds of government functions that are legitimate and large numbers of other things that fall outside the sway of proper government action. And if one wants to get a essential sense of where it is that one goes without figuring out exactly how one gets there, I would say that the functions are the ones that I mentioned in the libertarian state. I think it also has to deal with infrastructure and taxation. I think it has to deal with the provision of public goods. And I think it probably has to deal, though on delicate tiptoe, with the regulation and prohibition of various kinds of monopoly, or recognizes the real dangers that can take place when an administrative state starts to deal with that rather slippery subject. So you are now trying to look at a middle kind of a position, and the question is, how is it that you articulate it and defend it? Well, that's the first part of the thing. Now, the second kind of question is, how is it that we think about legal rules generally? And I'm going to try to be a little bit more of a lawyer and a little bit less of a political scientist for at least a minute. And here again, there are kind of three ways in which you can think about the law. I'm going to mention the two that I'm deeply suspicious of and try to indicate the third, which I think is much more moderate and sensible than either of the extremes. One of the things that's true when you're young in this world is that you believe that the class of deductive truths about social matters is rather larger than it really turns out to be. And so the great temptation of the strong libertarian thought, for which I was very, very fond and still have a lot of fondness for, was that somehow or other you could axiomatize it and sort of